دنگ رادیو کردانه است لباژیر لاهه.
دنگ گشتی آزادی خوازیل و دموکراسی خوازیل دولات کردستان.
دنگ ادب و هنر و شهرستانیت.
دنگ آشتی و دادپروری و یکسانی.
دنگ ولات خمان کردستان لرستان و لکستان.
دنگ خوشکایتی و برایتی گشت مردم زورله کریای ایران.
من آرزو کنم که یک روزی جمهوری اسلامی محاکمه عادلانه بود و این محاکمه سیده برای دادگاه لاهه ایران تریبونال شرکت بکنیم و 6 کیلو وکیل اروپایی تصمیم کردن که ایران محاکمه بکن بر علیه جنایتی که در عرض 30 سال انجام داد.
این ریلو گوشتریل عزیز رادیان کردانه های من در کاخ صلح و
من معذرت میخوام. جان اجازه عکس برداری، فیلم برداری، مصاحبه اصلا ندارید.
اینجا نداری؟
اینجا اجازه ندارید.
من جان حواست باشه توی بیرون از در اجازه نداری.
از خودش بپرس جان.
I don't know. Maybe yesterday. Don't have it.
حالا هشت نباشم
پیدا نکردی ولی
I'll carry on doing what I do.
It's okay.
اجازه تانی بگیر. آره عکسی مالی کسا بگیر. I might film.
If you have a few minutes.
Now, if anybody asked you, do I have a few minutes, what would your answer be?
Well, a few minutes, I will say, okay, give me this few minutes.
Yeah, because that's a condition there, right? It could turn into a few hours.
No, 5 minutes maybe.
What you do about photographers who are sort of generally getting in the way?
He's a journalist, and he's her husband, and he's, he just make a film because we have a TV 2 hours a week.
هدف ارائه این واقعیت تلخ تاریخی برای قضاوت در مقابل قوانین بین‌المللی در پیشگاه مردم ایران و جامعه جهانی است. مقصود آن است تا نشان داده شود که حتی چنانچه نهادهای رسمی قانونی به هر دلیلی نخواهند و یا نتوانند در دسترس مردم باشند، مردم آرام نخواهند نشست و دست از تلاش‌های خود برای هدف رسیدن به عدالت بر نخواهند داشت. حقانیت این دیوان را مردم عدالتخواه ایران و تمامی جهان به آن تقویض می‌کنند. کسانی که به حقوق بشر و پایان دادن به خشونت احترام می‌گذارند و خواهان رعایت حقوق بشر هستند. کسانی که طلب اجرای عدالت هستند و حاضر نیستند اجازه بدهند تا گذشته تاریک بر وجدان جمعی آنان سایه‌ای همیشگی بیفکند. ما امیدواریم که این اقدام قدم مهمی در راستای یک فرایند گسترده‌تر برای یک التیام عمومی در ایران و قبول مسئولیت برای جنایات گذشته باشد. ما امیدواریم که این اقدام در آینده منجر به تشکیل هیئت‌های حقیقتیاب و برگزاری دادگاه‌های عادلانه در ایرانی آزاد و مردم سالار باشد و چنان دستاوردهایی داشته باشد تا دیگر در هیچ زمانی شاهد تکرار چنین جنایاتی نباشیم. جمهوری اسلامی ایران طی نامه‌ای به تاریخ 22 شهریور 1391 از طرف کمیته راهبردی حقوقی ایران تریبونال به سفارت آن در شهر لاهه تحویل داده شد و از برگزاری این دادخواهی آگاه شده است. 3 نسخه از گزارش کمیسیون حقیقتیاب که بر پایه اظهارات گواهان که در نخستین مرحله این دادخواهی در تیر ماه 1391 در لندن شرکت کردند، تهیه و به سفارت جمهوری اسلامی در لاهه ارسال شد و از آنان دعوت به عمل آمد تا با شرکت در این دادخواهی فرصت دفاع از خود را داشته باشند. هرچند که قصد از این دعوت فراهم کردن فرصت واقعی برای جمهوری اسلامی در شرکت در این دادگاه بود، اما جمهوری اسلامی به این دعوت پاسخی نداد و از حضور در این دادگاه برای دفاع از خود امتناع ورزید. با این وجود این امر به هیچ وجه بی‌طرفی این دادگاه را به زیر سوال نمیبرد، چرا که این دیوان قضاوت خود را بر پایه عدله ابرازی و با استناد به قوانین بین‌المللی ارائه خواهد داد، حتی اگر جمهوری اسلامی با عدم شرکت خود در این دادرسی هیچ گونه دفاعی از خود ارائه نکند. اختیارات این دیوان محدود به رسیدگی مسئولیت جمهوری اسلامی در انجام جنایات است و نه مسئولیت افرادی که در آن دست داشتند. البته مسئولیت دولت در قانون بین‌المللی شامل مسئولیت محاکمه مرتکبین جنایت علیه بشریت است و ما به این موضوع رسیدگی خواهیم کرد. ولی مسئولیت‌های فردی این جنایات فرایند دیگری است با پیچیدگی‌های قانونی مربوط به خود و البته امکان دارد که این موارد در آینده مورد بررسی قرار گیرد و از این جهت دادخواهی ما در اینجا به هیچ عنوان آخرین مرحله رسیدگی به این جنایات نیست، بلکه این فقط قدم اول است که با عیان کردن حقایق تاریخی در یک روند معتبر و قانونی در برابر یک دادگاه مستقل و بی‌طرف زمینه را برای پاسخگویی و مسئولیت‌پذیری فراهم می‌سازد. با در نظر داشتن یک چنین زمینه‌ای ما امروز در اینجا گرد هم آمده‌ایم تا به یکی از موارد فجیع بی‌عدالتی در قبال مردم ایران بپردازیم و موجبات جبران آن را به نوعی برآورده کنیم. نقض فاحش حقوق اولیه انسان‌ها طی اولین دهه حاکمیت جمهوری اسلامی پس از به قدرت رسیدنش در سال 1357 آنچنان سهمگین و هولناک است که هیچگاه مشمول فراموشی نخواهد شد. این جنایات از همان اولین روزهای پس از انقلاب آغاز شد که جمهوری تازه به قدرت رسیده تلاش می‌کرد با از میان برداشتن مخالفین خود از طریق زندانی کردن آنها و اعدامشان، چه با تیرباران یا حلق آویز کردنشان، پایه‌های خود را مستحکم کند. اما این جنایات با تداوم مطلق قدرت توسط آیت الله خمینی و طرفدارانش بین خرداد ماه 1360 تا تابستان 1367 به اوج خود رسید و به کشتار بی‌سابقه هزاران زندانی سیاسی و عقیدتی منجر شد. در حالی که ما آمار دقیقی از اعدام شدگان در تابستان 1367 را در دست نداریم، اما تعداد آنان دست کم بین 4000 تا 5000 تن تخمین زده می شود. بدون چشم پوشی از دیگر جنایات مرتکب شده در دیگر دوره‌های زمانی در طول حاکمیت جمهوری اسلامی که به بررسی و رسیدگی آنها نیز نیاز است، حضور امروز ما در اینجا مشخصاً برای رسیدگی به جنایاتی است که بین سالهای 1360 و 1367 به وقوع پیوست که لااقل بین 15000 تا 20000 از شهروندان ایرانی اعدام شدند و تعداد بیشماری مورد شکنجه، تجاوز جنسی و حبس غیرقانونی واقع شدند. تمامی این جنایات بر پایه نظریات سیاسی و مذهبی یک حکومت تمامیت‌خواه که به دنبال قدرت مطلق بوده و هیچ گونه مخالفتی را از میان شهروندان علیه خود برنمی‌تابد بود. در اینجا شایان اهمیت است به یاد داشته باشیم که جنگ خانمانسوز ایران و عراق که در سال 1359 آغاز شد و چندین سال ادامه یافت، با آغاز اوجگیری سرکوب‌ها همزمان بود. جنگ بهانه‌ای برای تشدید سرکوب وحشیانه حکومت بر علیه نیروهای مخالف شد. با وجود این از نقطه نظر
Before you go to a new topic, pick a time that suits you. One of the judges, Judge Mansfield, would like to take up an issue with you about liability, individual and state responsibility. Would you indicate when it would be suitable to you to deal with that?
Mr. President, I'm at the disposal of the court at any time that it wishes to pose.
Well, I suggested two of you deal with it right now.
Please.
Thank you, Mr. President. I'm sorry I didn't necessarily want to interrupt your flow of thought, so I'm usually down there, so
I'm familiar with the difficulties. It's just that you've been through a passage recently, and I think it's the core of what we're trying to do here. And it may be important for us to understand and everyone else to understand exactly the framework here. I take the view that state responsibility is not a fiction. It rests on the shoulders of individuals at the end of the day who contrive a system. And so my question is that since Nuremberg, there has been a very strong concept for individual responsibility, certainly in international criminal law. That was the whole point. And also, even though Iran hasn't signed up to the ICC, international customary law existed before 2002 and had a concept of crimes against humanity which would fit individuals. So my concern is, how do we approach individual responsibility? I know you're saying it's for the future, but we're going to hear witnesses, I think, who may be able to identify, they may not wish to, perhaps they're capable of identifying people. And when we come to form judgments, how do we fit individual responsibility into this framework if you're saying, in a sense, the mandate is state responsibility? So I'm sorry, it's a long question. Do I make myself clear? Yes, of course. Thank you for that question, Judge Mansfield. As I briefly alluded in my presentation, and I will elaborate on this theme further, the mandate of the tribunal is to look at state responsibility, an aspect of which is to ensure that individuals responsible for crimes against humanity are brought to justice. So in that sense, although we do not have individual defendants on trial here, the question of the culture of impunity which has prevailed since the commission of those crimes is of direct relevance to the question of state responsibility. We know, for instance, from the Genocide Convention and other international instruments which relate to individual criminal responsibility that states have a responsibility to ensure that individuals who have committed such crimes are brought to justice. And you will notice from the report of the Commission, which my colleague Mr. Cooper will address after my presentation, that in the first phase of the tribunal, several witnesses identified, for instance, individuals that were members of the Death Commission that in 1988 was responsible for sending political prisoners to their death after what cannot even be described as a trial, after an inquisition lasting often just 1 or 2 minutes. So to the extent that we can establish that the identity of those individuals is known, is even notorious, and still the Islamic Republic has failed to take any action, we believe that that is a question relevant to state responsibility. But for obvious reasons, the steering committee has not established the mandate of this tribunal as a criminal trial with individual defendants.
Thank you for dealing with that. We will proceed with your submission in a minute.
Thank you, Mr. President. اعدام‌های گروهی، شکنجه‌های از پیش برنامه‌ریزی شده، تجاوزات جنسی و دستگیری‌های خودسرانه طی این دوران بدون شک یکی از خونین‌ترین دوران تاریخ معاصر ایران را تشکیل می‌دهد. اینها نه تنها ارتکاب جنایات در علیه مردم ایران هستند، بلکه جنایات بر علیه بشریت محسوب می‌شوند. جنایات بر علیه بشریت جنایاتی هستند که به جامعه بین‌المللی مربوط می‌شوند، چرا که تمام بشریت را مورد تهاجم قرار می‌دهند. در مقام دادستان این دادرسی ما وظیفه خود می‌دانیم که در پیشگاه این دیوان محترم نشان دهیم که نقض فاحش حقوق بشر و جنایات جمهوری اسلامی بر اساس داده‌های حقوق بین‌الملل جنایت بر علیه بشریت محسوب می‌شود و جمهوری اسلامی ایران در مقابل جامعه جهانی باید مسئولیت آن را بر دوش بگیرد. همانطور که پیشتر به آن اشاره شد، در اولین مرحله این دادخواهی که بین 22 خرداد تا 22 تیر ماه امسال در شهر لندن برگزار شد، یک کمیسیون حقیقتیاب متشکل از 6 شخصیت برجسته حقوقی و فرهنگی گواهی‌های ارائه شده از سوی 75 تن از جان بدربردگان و بستگان قربانیان این جنایات را دریافت کردند و شنیدند. این گواهان معرف طیف وسیعی از گروه‌های سیاسی، ملی و مذهبی به شمار می‌آمدند که بعضی از آنها هدف خشونت‌های دولتی فقط برای ایجاد رعب و وحشت در درون جامعه ایران انجام گرفته است. بسیاری از ما که در مرحله قبلی حضور داشتیم توضیحات دلخراش را به یاد می‌آوریم که هر یک از شاهدان بازگو کردند. گفته‌های آنان بازگو کننده واقعیت وحشتناکی از آن جنایات بود که با صمیمیت انسانی به ما فهماند چرا این جنایات را نمی‌توان و نباید فراموش کرد. به ما فهمانده شد کسانی که این جنایات را تحمل کرده و با آن زندگی کرده‌اند تنها زمانی می‌توانند فرایند یک التیام را به نوعی آغاز کنند که عدالت و قبول مسئولیت در قبال این جنایات تحقق کرده باشد، پیدا کرده باشد. ما سخنان و شهادت دردناک مادری را شنیدیم که تمامی فرزندانش را از دست داده و خواهرش نیز همراه فرزند 11 ساله‌اش اعدام شده بود. ما سخنان اشکبار زنی را شنیدیم که تلاش کرده بود تا بقایای برادر خود را در گورستان دست جمعی خاوران از زیر خاک بیرون بکشد. ما شهادت دردناک زنی را شنیدیم که همسرش در حال آرامش دادن به پسر 14 ساله‌ای بود که قبل از اعدام مادرش را صدا می‌زد. ما سخنان مادری را شنیدیم که فرزند 15 ساله‌اش به خاطر داشتن اعلامیه سیاسی در جیبش تیرباران شد. با اخذ پول گلوله در برابر دریافت جسد پسرش بی‌عدالتی در قبال این مادر داغدار به اوج خود رسید. ما شهادت و اظهارات کسانی را شنیدیم که به دنبال فتوای آیت الله خمینی در سال 1367 که خواهان اجرای خشم و کینه انقلابی علیه زندانیان سیاسی بود، شاهد اعدام همبندان خود بودند. ما شنیدیم چگونه قبل از آنکه این زندانیان به قتلگاه فرستاده شوند از آنان به سادگی پرسیده میشد آیا به جمهوری اسلامی وفادار هستند یا نه. اظهارات زنی را شنیدیم در حالی که باردار بود، در زیر شکنجه، تنها گزینه‌ای که داشت یا اعتراف بود یا از دست دادن فرزند به دنیا نیامده‌اش. ما گواهی و اظهارات تعداد بیشماری از زنان و مردانی را شنیدیم که به گونه‌ای فجیع روزهای بسیاری متحمل کتک خوردن‌ها و شکنجه‌های روحی و جسمی شده بودند. ما سخنان زنی را شنیدیم که به گونه‌ای فجیع در زندان مورد تجاوز جنسی قرار گرفته بود. و ما همینطور آگاه شدیم که هیچ یک از اعدام شدگان در یک دادگاه عادلانه و مستقل مورد قضاوت قرار نگرفتند. هیچ یک از آنان از حق داشتن وکیل مدافع را نداشتند و هیچ فرصتی در اختیار آنان قرار نگرفت تا از خود دفاع کنند و در بیشترین موارد تنها جرم آنان این بود که رژیم جمهوری اسلامی باورهای سیاسی و یا عقیدتی آنان را تایید نمی‌کرد و بر نمی‌تابید. به دنبال کوشش وسیع رسانه‌ای مرحله نخست این دادرسی تخمین زده می شود که میلیون‌ها نفر در ایران و جهان از آن مطلع شدند. جمهوری اسلامی ایران برای نخستین بار به این جنایات اعتراف کرد و در صدد برآمد تا از این کشتارهای جمعی تحت لوای قوانین بین‌المللی از خود دفاع کند. سید محمد مهدی پیامبری رئیس هیئت حقوق بشر وابسته به وزارت اطلاعات جمهوری اسلامی طی انتشار مقاله‌ای از این کشتارها دفاع کرد. پیامبری در این مقاله که به تاریخ 10 مرداد ماه 1391 توسط سرویس خبری برهان انتشار یافت، اظهار کرده است زندانیان اعدام شده منافقین بودند. این نام بار شدید مسخری دارد و به معنی دروغ و یا ریاکار است. و به نظر ایشون از آنجایی که اینان دشمنان خدا و جمهوری اسلامی بودند، اعدامشان طبق موازین و قوانین بین‌المللی موجه بوده است. نکته قابل ملاحظه آن است که پیامبری می‌نویسد زندانیانی که اعدام شدند مشمول محاکمه در یک دادگاه منصفانه نبودند، زیرا که از آغاز سال 1367 و به بعد آنها بخشی از نیروی نظامی دشمن بودند. جمهوری اسلامی در تمام دوران حکومتش اعمال خشونتبار و اعدام‌های خودسرانه را با این گونه بهانه‌ها توجیه کرده است. بنابر این منطق هر کس که موجودیت حکومت اسلامی را تهدید کند و یا مقابل آن ایستادگی کند میتوان او را خودسرانه اعدام کرد. البته که چنین موضوعی با هیچ یک از قوانین بین‌الملل همخوانی ندارد. به علاوه بیشترین زندانیان سیاسی صرف نظر از وابستگی گروهی صرفاً فعالان سیاسی بودند که هیچ گونه سابقه درگیری در مبارزه مسلحانه نداشتند. این شامل هزاران هم از زندانیانی میشد که اتهامات کوچک سیاسی به آنها نسبت داده شده بود و بسیاری نیز محکومیت‌های خود را به پایان رسانده بودند. ولی با این وجود در جریان کشتار جمعی زندانیان سیاسی در تابستان 1367 اعدام شدند. اما بحث ما در اینجا و در پیشگاه شما این خواهد بود که تحت قوانین بین الملل حتی کسانی که دست به مبارزه مسلحانه میزنند بنا به حکم قانون میبایستی از تمامی حقوق قانونی برخوردار باشد. ممنوعیت شکنجه و تجاوز جنسی مطلق است و هیچ گونه نسبیت و یا رابطه‌ای با جرایم زندانی ندارد. ممنوعیت محاکمه ناعادلانه و غیر منصفانه مطلق است، چه رسد به صدور حکم اعدام در یک دادگاه ناعادلانه و غیر منصفانه. هیچ توجیهی برای این گونه اعمال وجود ندارد، حتی اگر متهم درگیر مبارزه مسلحانه بوده باشد. از نقطه نظر قوانین بین الملل، اعمال کسانی که قربانی نقض فاحش حقوق بشر بوده‌اند دلیل محسوب نمی‌شود. این بدان خاطر است که برخی از موارد حقوق بشر، همانطور که پیشتر به نمونه‌ای از آنها اشاره کردم، مطلق به شمار می‌آید. هیچ گونه توجیهی برای جنایاتی که انجام گرفته است وجود ندارد. Turning now to the second phase of proceedings, the prosecution's objective is to establish before this tribunal that the pattern of serious human rights violations established in the Truth Commission's report of 30 July 2012 that my esteemed colleague Mr. Cooper will address further, that these serious human rights violations qualify as crimes against humanity as that term is defined in international law. Article 7 of the Statute of the International Criminal Court, adopted at the Rome Conference in 1998, is an important point of departure for defining this international crime. With a few exceptions that are largely irrelevant for present purposes, Article 7 contains a widely accepted definition of this crime, which applies to the events in Iran in the 1980s as customary law, alluding once again to the insightful question asked by Judge Mansfield in this respect. Customary law, of course, means that it applies irrespective of whether the Islamic Republic of Iran ratified a particular treaty or convention. And of course, this is a widely recognized source of international law that is beyond dispute as indicated in the jurisprudence of international courts and tribunals. I shall address the historical evolution and customary law status of crimes against humanity in much greater detail in our closing submissions. For present purposes, I wish to simply emphasize its main elements and how these will correspond to the case that we put before you. First, crimes against humanity entail the commission of serious violations of human rights or acts which can be assimilated to serious violations of human rights, as listed in Article 7, Paragraph 1 of the Court statute. Second, it entails the multiple commission of such acts as part of a widespread or systematic attack against a civilian population, in particular pursuant to or in furtherance of state policy. With respect to the first element, the serious human rights violations under Article 7 include murder under paragraph 1, subparagraph A, which encompasses arbitrary executions as well as death resulting from torture or other serious mistreatment where death is foreseeable. It includes torture under paragraph 1, subparagraph F, which is defined as the intentional infliction of severe pain or suffering, whether physical or mental, upon a person in the custody or under the control of the accused. It includes rape under paragraph 1, subparagraph G, or any other form of sexual violence of comparable gravity. It includes under paragraph 1, subparagraph E, imprisonment or other severe deprivation of physical liberty in violation of fundamental rules of international law, which of course encompasses imprisonment without a fair trial or imprisonment on grounds of political or religious beliefs. It is also important to point out that one of the underlying acts of crimes against humanity includes, under paragraph 1, subparagraph H of Article 7 of the statute, the crime of persecution against any identifiable group or collectivity on political or religious grounds. Thus, in addition to responsibility for large-scale serious human rights violations, there is additional responsibility where such violations are committed on the listed discriminatory grounds. Article 7, paragraph 2, subparagraph G of the court statute further clarifies that persecution means the intentional and severe deprivation of fundamental rights contrary to international law by reason of the identity of the group or collectivity. Thus, where Iranian citizens are imprisoned and subject to abuse and executions based on their political or religious beliefs, this may amount to the crime of persecution. This, we will establish, applies forcefully not only to the case of political prisoners and prisoners of conscience, belonging in particular to a number of leftist groups, but also to those such as Kurds and Arabs, who were often singled out on grounds of ethnicity or religion, and the case of the Baha'is, who were targeted solely because they were deemed to be members of a religious heresy or wayward sect. In respect to these acts, it should be noted that domestic law, as I shall elaborate further in our concluding submissions, domestic law is not an excuse or defense to crimes against humanity. So while arbitrary executions and discriminatory treatments amounting to the crime of persecution may or may not have been permitted under the laws of the Islamic Republic at the time, and our expert witness, Dr. Hidayat Matin Jaftari, later today will speak to you about the Islamic constitution and penal laws that very often justify, at least on the part of the regime, this mistreatment, that those laws do not shield the Islamic Republic from responsibility under international law. In summary, these are the types of serious human rights violations that are required to establish crimes against humanity. However, such violations are not by themselves sufficient to satisfy the elements of this grave international crime. The second, and perhaps far more important element, is the context within which such crimes were committed. And as you noted, Mr. President, the focus of these hearings is building on the report of the Commission to establish that wider context within which those individual atrocities were committed. So it is this contextual element that elevates ordinary human rights abuses to the scale and gravity of crimes against humanity. It is clear that not every human rights violation constitutes an international crime, let alone the very serious offense of crimes against humanity. Once again, we turn to Article 7, Paragraph 1 of the court statute, which clarifies that violations such as murder and torture are crimes against humanity only when, and I quote, committed as part of a widespread or systematic attack directed against any civilian population. Paragraph 2, subparagraph A, further clarifies that this contextual requirement means, and I quote, a course of conduct involving the multiple commission of acts against any civilian population pursuant to or in furtherance of a state or organizational policy to commit such an attack. Some have argued that in this respect, the requirements in the Statute of International Criminal Court of state policy may be even more exacting and restrictive than customary law, which does not necessarily require formal state policy. In any event, we believe that the evidence before you will establish that indeed these crimes were committed based on the state policy of the Islamic Republic. Also, as I shall further elaborate in our concluding submissions, unlike charges of war crimes, there is no requirement of a nexus with armed conflict under customary law during the relevant period in the 1980s, such that crimes against humanity may be committed irrespective of whether they were connected in any way with the Iran-Iraq War. Furthermore, those that are prisoners, especially those that are imprisoned on political or religious grounds, are deemed by international law to be civilians for the purpose of crimes against humanity. Thus, as we shall establish, the issue of war is simply not relevant for a determination that these acts constituted crimes against humanity. With respect to these two elements, the prosecution will establish, based on the evidence and based on the further testimony provided at this hearing, building on the Commission's report, that serious human rights violations, such as arbitrary executions, torture, rape, unlawful imprisonment, were committed, and that these violations were committed further on political or religious grounds, and that these violations were committed on a widespread or systematic basis involving the multiple commission of these crimes pursuant to or in furtherance of the state policy of the Islamic Republic of Iran. That, Mr. President, concludes our opening submissions. Unless the Honorable Tribunal has any further questions, I now ask you to give the floor to my colleague, Mr. John Cooper, who will provide our further opening submissions on the factual aspects of this case.
Thank you, Mr. Akbar. Just a moment, let's just see whether any of the members of the Tribunal. Yes, ma'am.
Thank you very much. I just want to return to the question of state responsibility and individual criminal responsibility for these offences. It's my understanding that in the course of the proceedings, witnesses might identify particular individuals who are connected to the commission of some of these crimes. And name those individuals by name. Could you foreshadow for us how you expect or what you would like this tribunal to think of the name of such ones?
The question that you are asking specifically is whether in its deliberations and judgments the tribunal should make reference to individual names. Do I understand you correctly, Judge?
Yes, yes.
You will notice from the report of the Commission that, and Mr. John Cooper will address this shortly, that the Commission does note that particular witnesses did name, for instance, members of the Death Commission that was responsible for sending people to be executed, in particular in relation to 1988. As I try to explain briefly, we certainly believe that the question of individual responsibility is of direct relevance to these proceedings, insofar as the failure and the continuing failure of the Islamic Republic of Iran to conduct any investigation, let alone to prosecute anyone that has been involved in the commission of these crimes, is clearly a violation of Iran's obligations as a matter of state responsibility. In that regard, it may be relevant for the tribunal, based on the evidence before it, whether in the Commission's report or the testimony that we'll hear, to allude to the fact that at least certain individuals are particularly notorious and well known, which may be a relevant evidentiary inference when concluding that the Islamic Republic of Iran has failed to investigate or prosecute. Of course, we would submit that this is hardly a case where we even have to argue that the state merely acquiesced in certain crimes. Our submission is that the mass executions, the reign of terror, was at the core of the policy of the Islamic Republic as it consolidated power in the first decade of the revolution. So it would naturally follow from that that impunity would not be a mere matter of oversight when the state itself is committed to committing mass atrocities. But it may be relevant to allude to the fact that in addition to that very obvious context, that the identity, at least of certain perpetrators, is particularly notorious, and as we shall further submit, many have been appointed to the Supreme Court, to the Cabinet, to the parliaments of Iran. What we are trying to avoid, however, is to transform this into a criminal trial, because the view, at least, of the steering committee would be that given the specificities of individual criminal responsibility and the impossibility under present circumstances of having a defendant with proper submissions, that it may not be appropriate at this stage, at least, to address those issues. And as I mentioned, it is not that this is the end of the road, but this is only the beginning of a process of addressing these crimes. And if I may just very briefly allude to one example. Let's say we have an individual who is a member of the Death Commission, and several witnesses identify this individual and say that this individual was responsible for sending my fellow prisoners to be hanged without any form of a trial based purely on their religious beliefs. Now, from a point of view of criminal liability, it may be self-evident that that individual is criminally liable in the sense that there's a very direct, immediate participation. But as one moves up the so-called chain of command, it becomes somewhat more difficult to establish, beyond the matter of moral responsibility, that individuals bear criminal liability merely because they occupy positions of authority. Because one would have to address the question of what was the chain of command through which the fatwa of Ayatollah Khomeini was executed through the various ministries and branches. And we all know, those of us who practice before international criminal tribunals, the difference between de jure and de facto authority, which are very, very complex evidentiary issues. So forgive me for this somewhat long answer, but I'm just trying to explain some of our thinking about why the issue at this stage should be focused on state responsibility and the extent to which individual responsibility is relevant, but within that limited context.
Thank you. Mr. President, I just wanted to note that, I appreciate the response, but just to note, not to just go on to note that, crimes against humanity do not commit themselves. They're committed by individuals, nor are they committed by a faceless state. And to that extent, I appreciate the response that individuals who are responsible, although it is not the role of this tribunal to find particular individuals liable criminally for those offenses. Thank you.
Sorry to delay. It's a follow-through to that answer, which I think is extremely important for witnesses and the public. Although it may be difficult to prove actual knowledge in a chain of command, evidentially, there are strong inferences that can be drawn if somebody must have been aware of, if you like, a system of death and execution, and had the power to prevent it. And it is at that point that that person becomes responsible. I appreciate it's just that I think I particularly would like to clothe the regime with personality rather than leaving it just as state responsibility. Do you see where I'm going? I think in all of these cases, the person who pulls the trigger often carries the can, when actually we should be looking at who has authorised it, because they can fade into the background, but that doesn't mean to say they're not right in the foreground. Do you follow what I'm saying?
I would just reinforce what the honourable judges have said with the famous quote of the Nuremberg Tribunal that international crimes are not committed by abstract entities, they're committed by individuals, and it's only in holding individuals responsible that we can enforce international law. So in that regard, as I said, a fundamental element of state responsibility is the obligation of the state to investigate and prosecute, and I indicated in my opening submissions why under present circumstances the Iranian courts, instead of investigating and prosecuting, are actually instruments of repression themselves, and why in the absence of international criminal jurisdiction we appear before this tribunal as a first step in achieving justice. The question, of course, is how does one begin to select the possible list of defendants, even if this was a criminal tribunal? How many tens of thousands of people were involved in these mass executions over a decade? The numbers are going to be quite significant. And having been a former prosecutor, and I know elements of the tribunal have had similar experiences, one of the very difficult issues is what we would call target selection. Does one go after those that are politically popular or known? Does one go after the executioners? Who is more responsible, the man that issues the fatwa on top of the chain of command, or the individuals that are the willing executioners along the way? So these are very, very legitimate and profound questions, and I would submit that these are matters which the Iranian people and the international community will have to grapple with for many years to come. In a future democratic Iran, where hopefully the Iranian courts themselves, independent and impartial courts, can prosecute these crimes, or perhaps a truth commission along the South African model, which addresses the wider victim community in ways that a court cannot. These are very important questions that we must engage in a conversation about. But the issue really is that beyond the fatwa of Ayatollah Khomeini, which is included in our submissions and which Mr. John Cooper and others will address, which shows the supreme leader of the Islamic Republic, who's not just a religious figure, but he is in effect the head of state. issuing a fatwa for mass murder, where is the line that connects that fatwa to the executioners, to those who were members of the Death Commission representing the different ministries, the judiciary, the intelligence ministry? And all I'm submitting is that these are very complex evidentiary matters, which may be beyond the scope of the present proceeding, but which must certainly at some point in the future be addressed when the opportunity exists. And I would simply say that while the tribunal should certainly address individual names where it feels that there is sufficient evidence, at least to establish a prima facie case of responsibility, that we should try and avoid naming names where there is insufficient evidentiary basis at this stage and not create the impression that whoever is not named is somehow not potentially guilty of these crimes.
Thank you. So engaging debate, I think we need to move on. Thank you very much, Mr.
Can I thank Mr. Arshaban for his eloquent opening address to this court. Mr. President, distinguished members of this tribunal, in the dark summer of 1988, prisoners in the Go-Hartash establishment communicated with each other in Morse code. By tapping on the cold walls of their cells, they spread the news of the arrival of the mysterious Death Commission, whose mission it was to investigate the piety of jailed political prisoners. The tapping continued, and an unprecedented spate of executions were unleashed. Today, the men and women whose only means of communication some 24 years ago was the sound that their fingers could make upon concrete, today and previously in June can speak to this court without fear. Their determination to expose the barbarities of their unrelenting oppressors has not waned. In fact, it has over the years become stronger. Now they may speak loudly and with confidence as the Iranian people listen and await historic justice with bated breath. In June, a Truth Commission was held in London, and we are grateful for, amongst others, the assistance and support of Amnesty London in providing that venue. It heard from 75 brave witnesses. Some of them presented oral testimony. Others presented written evidence. All of it compiled in a commission's report, which I will respectfully and hopefully briefly refer this court to in a moment. Each and every one of those 75 witnesses at the commission were victims. Victims of the Iranian regime, say this prosecution. They pieced together a harrowing tale of unimaginable torture, abuse, and execution. The Commission was impressed by their courage, and we express on their behalf the deepest gratitude to all those who supported the pursuit and still support the pursuit of international justice. The Commission received international support by people from all over the world, including Archbishop Desmond Tutu, who sent the Commission at the start of its proceedings a warm and supportive message. Honourable judges of this tribunal, I commend the Truth Commission's extraordinary diligence in the composition of this report and commend this historic document to you. It is the tip of an iceberg of evidence of the crimes against humanity that the Islamic Republic of Iran inflicted upon its people in the 1980s. The prosecution here today express its full faith in the integrity and accuracy of the Truth Commission's work. During the course of this opening to you, I will be referring to the Truth Commission document, which I hope the court and each individual judge has before them. It is important to begin, perhaps, with a reference to the procedure at that commission, so that this tribunal can, with satisfaction, be comfortable with the findings that were made. Can I take the court immediately, please, to this document, and to page 9, please. Page 9 of the document. And paragraph 25. I'm not going to, on the paragraphs that I refer to during this opening, read every single paragraph I refer to verbatim. The tribunal is more than capable in due course at a later stage in absorbing and perusing the document, which I know they have already read and considered. But to assist this court, paragraph 25 is of assistance when the court considered the procedure adopted by the Commission. It is important to emphasise that Commission developed its own procedure. The steering committee established a framework for bringing people together. It was the Commission's sole responsibility, as indeed it is this tribunal's sole responsibility, for establishing that procedure. There the court see that each witness submitted a written statement which was distributed to the members of the Commission in advance. The statements were originally written in Persian and translated for the benefit of the Commission. Accuracy of that evidence was vital. Indeed, accuracy and comfort of witnesses giving evidence is vital. And we have ensured, not only at that Commission, but in the proceedings before you over the next few days, that the primary objective for us of witnesses that we are presenting to you is the comfort of that witness and the easiest possible way for them to deliver their evidence to you accurately and as best evidence. The prosecution invite this tribunal to accept in due course the report of the Commission and to ratify it as its own fact-finding inquiry. You will find that this report sets out in chilling detail, we submit, how the Islamic Republic of Iran systematically terrorized its people as it sought to consolidate the Islamic Revolution, how it abducted dissidents in the dead of night, how it subjected them to kangaroo courts, how it viciously tortured them, and then how it murdered them in cold blood and dumped them in mass and often shallow graves. Every fact stated in the main body of the report that we commend to you is supported by a comprehensive set of references in Part E of that report, which points at those that read it directly to the relevant witness statements, some of which I will praise, I reassure the court, by no means the totality, but some of which I will praise and appear in Exhibit 3 of this report. In February 1979, in Pahlavi dynasty in Iran, there was a crumbling in the face of the revolution. The Ayatollah Ruhollah Khomeini was swept into power. In November, a referendum approved the new constitution of the Islamic Republic of Iran. The new theocratic state vested the supreme leader, and the supreme leader alone, with the power to interpret the will of God. The new regime wasted no time, we submit, in liquidating the old regime. Within a year of the adoption of the new constitution, a decade-long war with Iraq was underway. It took less than a year from that point on for the Islamic regime to turn its guns on the very political groups alongside which it had fought in the revolution. Many witnesses mention the infamous demonstrations of the 20th of June 1981 as a watershed moment, where there began the systemic elimination of all political dissent. The report, as this esteemed tribunal know and will further realise in the days ahead, make for discomforting reading, to say the least. Chapter 1 of that report, which I will refer the court to now, begins at page 13 of the document. The court will see that it identifies three distinct manners in which political dissidents were arbitrarily arrested and bundled away to prisons. In the first instance, dissidents forcibly disappeared. When their families attempted to discover the whereabouts of their loved ones, they were refused information, thrown red herrings, if you will, or directed to dead ends. In the second instance, dissidents were arrested after their houses were besieged by overwhelming man and firepower in the dead of night. And this court will read within the Commission's documents harrowing and direct evidence from people who underwent that terrifying ordeal. Their contents were ransacked and the inhabitants brutally attacked. In the third instance, they were arrested after being set up by former associates who were themselves acting under duress from inside prison. This, we submit, is a continuing trend as far as the activities of those oppressors were concerned. For as time went on, prisoners would be turned upon prisoners, to the extent even of killing each other. The duress and torture was not straightforward. There is zero evidence of any due process in the arrests we refer to. There were no warrants, no explanations, and no identifying documents. Some people were blindfolded and abducted after they were asked to accompany the Revolutionary Guards to the station for questions. Suspects were detained, says the evidence before you in this document, to be developed further in the next few days. But suspects were detained for long periods. The longest in evidence we present to this court being 18 months, without trial, in prisons, detention centres, or overflow facilities throughout Iran, and in, as you will hear and read, appalling conditions. They were then interrogated, blindfolded, and subjected to the most, we submit, senseless torture, most commonly to force them to confess or to divulge information. Without exception, the suspects were subjected to graphic torture. Can I take the court to page 146 of the Commission document? Page 146, please. Where the court will see the evidence of Saleh Sharafi. This witness, occupation at time of arrest, high school teacher, date of arrest, 1981. The court will see at page 146 what we submit is a graphic and helpful list of just some of the instances of torture witnesses either endured or witnessed directly whilst being held in the establishments they speak of. They are listed in 1 to 18 in that document. I'll not read them all, but some give a flavour of either direct, graphic and violent torture or more insidious methods, all designed to reduce the will of the individual who is subjected to them. Being held in cells with high humidity and moisture conditions, being severely hit by electrical cable, either being held in a cell in total darkness or in very strong lights. At 5, this court will see being tied to gallows for a long duration of time during the cold winter or hot summer months. Being forced to listen at number 8, or C, whilst other prisoners were being tortured or being kept in the torture room or rooms adjacent to it. At item 10, a regular, so we submit, form of torture operated at this time, Gaphan-style torture, a method of handcuffing where one hand over the shoulder to the back is handcuffed with the other hand. The body is hanged from some item, and the pressure usually, says the witness in this piece of evidence, breaks the shoulder. There are other items of torture there that this court, I know, will read, including deprivation of hygiene, medicine, and other basic requirements. Gapani, of course, is just one example of a medieval torture method we submit, which is used. There are, we sadly have to submit to this court, others. But psychological torture during this time was also every bit as agonizing. Solitary confinement and intimidation barely scratch the surface of a description within the evidence of this category of torture. Shockingly and memorably, evidence was presented to the Commission of mock executions, and we can only imagine how it must have felt to those who thought, on numerous occasions, according to the evidence we have, that they were about to be executed, right to the final moment of the trigger being pulled. One can only guess as to the effect that would have on any human being. And adding to that, experiences attested to of people being forced to watch fellow inmates being tortured. Or perhaps most appallingly recently, tortured in the presence of their own crying children. One would be hard-pressed to find a single moment in those prisons, we suggest, that could be defined as anything other than cruel, inhuman, and degrading. Prisoners were packed like animals to the slaughter, into cells so overcrowded that they had to sleep in shifts. Sanitary conditions were, suffice it to say, non-existent, medical assistance and food was deliberately denied. Prison officials, and I emphasise again, all this is based on the evidence we present to you. Prison officials used forced labour. Inmates were pressured to participate in televised confessions or recantations. To erode the morale of the prison population, this was a regular device. And there was no escape from indoctrination classes, which, with a savage irony, we submit, preached the treatises of the Supreme Leader. The witnesses of the Truth Commission were asked about their trials. One laughed and said, "When you say trial, I think you have something European in mind." We submit it goes further as far as torture is concerned. When you say torture, I think you have something European in mind. For those of us that perhaps are more used to looking at violations of Article 3 as far as the European Convention on Human Rights is concerned, and seeing torture, inhuman or degrading treatment often argued and defined as a slap or a punch, appalling though that is, this court will be stepping into a whole new world of torture, inhuman and degrading treatment, which even the forefathers who drafted Article 3 surely would never have had in mind. Let me take you, perhaps, to just a few examples of witnesses within the Truth Commission document on this matter. Page 115, please. This is the evidence at page 115 of Salha, who was 27 at the time of his arrest, and perhaps a common theme in occupation, another teacher. Can I ask the court, obviously I commend every word of these witnesses to you, but ask the court to look at page 115, the paragraph just under halfway down, which begins with "during the trial." During the trial, which is put in inverted commas by this witness, the judge had his underage son sit on his lap. Apparently this boy had been to many such sessions, because on a number of occasions he would interrupt his father and say, "Dear Dad, execute him too." To which his father responded, "All right, dear, we'll execute him as well." When I was taken out of the room, my interrogator torturer told me, says this witness, that he would be the one who would fire the final shot at my execution. Hearings lasted sometimes no longer than 2 minutes. Victims would be herded into court in packs, with whole hearings dealing with numerous people, because that, of course, is what they are and were, being dealt with in a totality of 8 or so minutes. There are and is a wealth of information, and is conveniently summarised beginning at page 26 of the Commission's report. I won't refer to it, but it's there for the court to peruse in due course, which deals with trial. Perhaps there's one thing missing, the inverted commas.
Would this be a convenient stage to take the adjournment?
Ask the court wills, of course.
We will adjourn for 15 minutes. Will everybody please ensure that they're back?